Can a collective bargaining agreement protect exempt employees from termination? To find out, you have to read Matter of Teamsters versus Town of Monroe. But it's 8 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Matter of Teamsters versus Town of Monroe. The citation for this case is 2023, New York Slip Opinion 02754, published by the New York Court of Appeals on May 23rd of 2023. This is a labor law case. The issue in this case is whether a collective bargaining agreement between public employees and the state can grant for-cause termination protections to an exempt employee. I'll explain all that in a moment. The law you have to understand to appreciate where this case fits in is a couple different things. First, the Taylor Law. The Taylor Law is a statute. It's actually called the Public Employees Fair Employment Act. It's found in Civil Service Law, Article 14 in the 200s. That law, it basically says that public employees are not allowed to strike. If there's a dispute between a public employee and their employer, which is the state, the Taylor Law guides how that dispute must be dealt with. And there's an organization called the Public Employment Relations Board, created by statute, that's designed to facilitate that entire dispute resolution process. The general public policy in the state under the Taylor Law is no strikes, no disruptions of service. And to accomplish that, there's a series of actions that can take place. An employee can make a complaint, then there'd be mediation, there could be a hearing, and ultimately there could be binding arbitration. And to embody these policies, there are periodic collective bargaining agreements that help facilitate the employee grievance process. Okay. And those collective bargaining agreements can cover a lot of things, including what kind of termination procedures, what kind of standard of proof has to be done to fire somebody who's a public employee. That's the first part. The second part you have to understand is that the Civil Service Law, under Civil Service Law 40, has set up different classes of public employees. There are 4 classes of public employees. Well, there are 2 big classes, classified and unclassified, but in the classified, there are 4 subcategories, and those 4 subcategories are the labor class, the competitive class, the non-competitive class, and lastly, the exempt class. And the reason why I'm using different hands is the labor class, the competitive class, and the non-competitive class are all subject to civil service examination. To get the job, you have to take the New York Civil Service Test. And if you do well, then you're eligible for different civil service jobs. But you also get protections. You can't just be fired willy-nilly. So it's a little harder to get in because you have to take a test. But once you're in, they can't fire you for no reason. You have to have just cause. They have to have a reasonable reason to fire you. But remember, there's 2 different hands I use. There's the labor class, competitive class, and non-competitive class, and then there's the exempt class. The exempt class is called exempt because it's exempt from the civil service exam. These are jobs that are public employee jobs, but you don't take a civil service test to get it. This is it's based upon, the jobs themselves are based upon the confidential nature of the position, the performance of duties which require the exercise of authority and discretion at a high level, or the need for the appointee to have some expertise, or personal qualities which can't be measured on an exam. So if you are a personal secretary to the mayor, that is probably an exempt class because the mayor has to have certain trust and certain discretion invested in the secretary or the deputy mayor. This person would be an exempt employee. They don't take a civil service test to get there, but they're also not protected by the termination clauses of CBAs, of collective bargaining agreements. Okay, so what are the facts here? The facts are, in 2012, the town of Monroe appointed a new secretary to the town planning board, which is an exempt civil service position. And in 2015, the town employees entered a collective bargaining agreement with the town, which encompassed a lot of different areas. It included specifically that the secretary of the town board would be part of that CBA, that collective bargaining agreement. It also allowed the town to terminate employees only for just cause, and other things as well. In 2017, the town terminated the secretary from the town planning board but they didn't give them all the protections of the CBA. Or didn't give them notice and a hearing and an opportunity to be heard and ultimately binding arbitration. They just fired the secretary. The Teamsters filed a grievance saying you violated the CBA. The town refused to address it, said this is an exempt employee. We don't want to even acknowledge this. And the Teamsters commenced an action to compel arbitration under the Taylor Law. The Supreme Court denied the town's motion to dismiss, saying you bargained for this in the CBA. The Appellate Division affirmed. It goes to the Court of Appeals. And here, the Court of Appeals reverses. The Court of Appeals says there's two steps when analyzing whether a dispute is subject to the binding arbitration provisions. Two steps are, number one, this is the quote they're called the may they do that test, the may they do that, and the did they do that test. May they do that and did they do that? Step one is may they do that. It examines the subject matter of the dispute. Is this the kind of subject matter that would be subject to binding arbitration? And here, avoiding the for-cause termination protection would violate public policy. They say the may they do that test basically says if granting the relief would violate a statute, decisional law, or public policy, then it's not arbitrable. And here it would violate it would violate all three. Specifically, they say the secretary is an exempt position. It's terminable at will. That's a characteristic of being an exempt position. And so for-cause termination are inconsistent with that characteristic of an exempt classification. It would weigh against it because then the employers, the appointing officers, must feel free to choose their employees as they please and terminate them as they please. They shouldn't have to fear what would happen if they want to fire them and have to go through a whole hearing about it. So basically the answer here is that since the dispute is not arbitrable under the CBA, if granting the relief would violate public policy, and here it violates public policy, then it's not arbitrable. They reverse, they say the town was okay to fire the secretary, and that's the case of Matter of Teamsters versus Town of Monroe. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.